where kids could not get to school easily. So, and I went and I got the deed, and I saw that it was, in fact, part of the deed, and it was granted to the public. Safe Routes to School was gracious enough to allow me to come, because after I spoke to people, initially they were like, okay, that's interesting, glad to hear it, some of them. Most of them, in fact, were open to listening to it. And I'm the one who reported to the Safe Routes to School Committee, hey, these people didn't even really know about it. Then something happened where they started getting really concerned. So, as I said, they graciously let me talk to them at the Safe Routes to School meeting. We did not have a productive conversation, so we decided, let's just shelve it. We never went to the Township Committee to ask to have it developed, because we weren't going to. And yes, it has mature trees, very mature trees. I had wanted to have it surveyed so that we could figure out a way to wind around those trees as much as possible, because I wouldn't want to cut down any trees. And Eagle Scout to cut down on expenses to do the other half from Linden Lane. So, I'm not going to talk too long, but my understanding, I did go to an attorney because there seemed to be some confusion about this. And I'm not saying that I'm going to litigate, but I am going to get to the bottom of it. I want to figure it out. It may be very complicated. They seem to think it's simple, the attorneys that I've gone to. But my understanding from them is that while the township may get rid of paper streets or easements such as drainage or sewer, in this case they do not have that right. I have evidence that this footpath does belong to the public. I'm going to read from the deed. It's back there. You may have it. It's a Brower to Pfeiffer deed, and it says it's this private property, and I know that it's private property, but it is subject to an easement for public use for foot passage only for an 8 feet wide walkway from Pine Street. They do mention Pine Street specifically, to connect at a point, and blah, 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 exactly how to do it, and they tell you exactly where it is. Then it says, together with the right to use with the public the easement for foot passage over the walkway referred to in the preceding paragraph. I also got the other deed for 75 Pine Street, which is more vague. It says it is also subject to easements and restrictions of record, and they mention that easement for the walkway. They don't say the public there, but they do say it in the Brower to Pfeiffer one. All right. This deed, I was told, this deed creates a right in individual members of the public to use the walkway. It's also listed, as you said, on the county map. The lawyer discovered that the actual ordinance that seemed to come about awfully quickly is actually based on a statute for the removal of a public street, highway, or public gathering or meeting place. In contrast, this footpath is a means of travel by footpath for public individuals, and so he determined that this statute that was referenced in the ordinance simply doesn't apply. We consulted with the EPA to find out about that. The chief, the Bureau of Legal Services, said we can't give you a public advocate for this. However,
sorry, you meant the DEP, because that's the document I saw.
Oh, I apologize, EPA. Okay. Passed along a similar, well, environmental protection, passed along a similar case in Denville, where they sort of had the same situation, apparently. And the state judge ruled that a local municipality does not possess the legal power to override an official deed of record covenant to eliminate something which belongs to the public. In terms of saying that it's abandoned, I personally have spoken to people that have used it, not recently. It is very overgrown. I've talked even to a Linden Lane person who said that they had used it. But that's not even, it doesn't matter, because Morris County, there was another similar situation where some group tried to say an easement was abandoned. And I have that, it's in the letter, but the court cited the settled principle of easement law that the mere non-use of an easement will not suffice to destroy the right That is also back there, and it is referenced. I will quickly touch on safety because we all care about safety for our children, and we care about safety for ourselves, all right? There was mention of the pond. I heard you say you didn't even want to talk about that, but I'm going to touch on it because I wanted to listen to the residents' concerns that came up about the pond. It's on the other end of the property, 274 feet away. It was there when the easement was put in. They knew it was there. And why would they do that if they were afraid of the pond? And it's more visible and closer to the surrounding streets, with many points of access from those streets than it is from the easement. I have exact numbers. Lincoln Circle is 160 feet from the pond. Pine Street is 236. Linden Lane is 155 feet. Horseshoe Drive is 200 feet. In contrast, the walkway is at its furthest at 274 feet from Seneca Pond. And we discussed Shun Pike endlessly. I was the one